PW1 is to discredit his evidence, what he had earlier deposed when I had cross-examined him. That is one ground. Recalled. I have completed my cross-examination completely on the very first day. On subsequent dates, on 2 instances, he was recalled to give further evidences.
Mere marking of a document would amount to its proof. Then
He'll show it to my witness. My witness will say, I don't know anything about the document. Then he will again recall his witness to mark it.
For a moment, if it is, for a moment, wait, sir, let me complete, sir. You have said, wait, sir. I will conclude it, my lord, and I can undertake saying that I would not even recall my witness. There is a reason why I will give that undertaking.
I do have a transaction. The transaction leads the
Not the case, my lord. There is no transaction. That's a very specific defense.
I'll know.
No, it's a specific
The
defense.
two is
311 application, 138 matter. My lord, the reason why I have sought for recalling this PW1 is to discredit his evidence, what he had earlier deposed when I had cross-examined him. That is one ground. The other ground is that to show that the present case is being filed in collusion with a builder. This is my case is this. My lord, earlier instance, if you're on my country,
application.
this is the third application. But one thing has to be considered is this reason, my lord. On the first instance, when he was recalled, I have completed my cross-examination completely on the very first day. On subsequent dates, on 2 instances, he was recalled to give further evidences.
He had filed application.
Yes, at their instance, 2 applications were filed.
Then third and secondary.
Applications excluding.
Excluding only. I'm telling. So they had filed 2 applications where they had led to on further evidences. On those fronts, though on the short adjournments were sought, the court had rejected, and within 4 days I've recalled, I've done even the cross-examination on the very same. It is not that.
Tell you not, the difficulty is not this. I'll tell what he wants to now show a document to which I am not a part. He wants to show, which is not at all related to this.
Mere marking of a document would amount to its proof. Then
now what will happen is he will recall, he'll show it to my witness. My witness will say, I don't know anything about the document. Then he will again recall his witness to mark it. My lord, the process, it's been posted for judgment 2 times. My difficulty is this. My lord, he'll file one, then every time, my lords, the trial court was posted for judgment, trial court allowed, despite my objections, trial court allowed it. It did not challenge, left it at that. Because, my lords, he filed his evidence.
It's not the case like that.
if it's posted for judgment, will
The
not.
situation is not like that, my lord. I'll just show it, my lord. The situation is not like that. The situation is not like that. If your honor may kindly see the typed order sheet they have given, my lord. For a moment, if it is, for a moment, wait, sir, let me complete, sir. You have said, wait, sir. My lord, the order sheet, what they have given in the typed copy, on 28/8 they have given. At page number 5, my lord.
Yes, sir.
This was the instance. In fact, at serial number 14, on the first instance, I lead DW1 evidence, my lord. At serial number 14, my lord, page 14.
138 proceedings, sir.
138 matter.
138.
At serial number 14 only, 3/1/2023, it indicates that accused was examined. DW1. On the next date, I would file an application saying that document the court said file one more application, 311 application was filed. This was marked. And at that stage, on 1/2/2023, DW1 was present. Counsel, the complainant counsel would not cross-examine. Subsequently, my lord, they take 2 dates. And on at serial number 18, if your honor may kindly see, serial number 18, they file a 91 application. At that juncture, without completing DW1's cross-examination. And on that 91 application, your honor may kindly see at page number 6, how many dates is gone. I have not dragged. Page number 6, my lord.
On one day, we will direct completion.
I will conclude it, my lord, and I can undertake saying that I would not even recall my witness. There is a reason why I will give that undertaking. Please.
Mere marking will not amount to its proof, sir.
Then again, if I
All right, yes. The petitioner is before this court, calling in question an order dated 6/8/2024, by which an application filed by the petitioner seeking recall of PW1 for further cross-examination is turned down. They heard so-and-so, facts in brief so-and-so, heard so-and-so. A transaction, the petitioner is the accused, the respondent, the complainant. The two have a transaction. The transaction leads the
Not the
com-
case, my lord. There is no transaction. That's a very specific defense.
ಆಯ್ತು ಅಲ್ಲಿ ನೋಡೋಣ.
No, it's a specific
The
defense. my lord.
the two are alleged to have a
Please,
transaction.
please.
The alleged transaction leads the complainant to the concerned court invoking section 200 of the CRPC for offense punishable under section 138 of the Negotiable Instruments Act. The issue in the list does not pertain to the merit of the matter. The petitioner and the respondent both have filed several applications seeking a recall of witnesses or summoning of documents under section 311 or 91 of the CRPC as the case would be. The present case revolves around the latest application filed by the petitioner for seeking recall of
Yes, yes.
recall of
Dated
PW1
6/8.
recall of PW1 for further cross-examination. This is turned down. The petitioner is at the doors of this court. The learned counsel appearing for the petitioner submits the circumstance which necessitated the application to be filed under section 311 and would also undertake that he would complete the further cross-examination on that very day and will not summon will not summon his witness to speak about the document that he is wanting to confront the complainant PW1. In the light of the said submission, the learned counsel for the petition respondent would submit that a direction be issued to complete the further cross-examination on the day that it is fixed. Tomorrow, ನಾಳೆ ಇದೆಯಾ? On the day that is fixed, ನಾಳೆ witness will come. On the day that is fixed, i.e. tomorrow, date ಹಾಕ್ಬಿಡಿ madam, tomorrow. And would submit that further applications of the kind should not be permitted. The learned counsel for the petitioner undertakes that he would not, the petitioner would not file any further application seeking recall of witnesses or otherwise, as the matter is posted for judgment twice, and twice over it is the applications are filed by the petitioner. In the light of this undertaking and the acceptance of the counsel for the respondent that the only direction that is to be issued is not to permit the proceedings to be dragged. I deem it appropriate to allow to pass the following order. The petition is allowed. ಇದು ಮೇಡಮ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ನಾಳೆ ಮ್ಯಾಟರ್ ಇರೋದ್ರಿಂದ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ರಿಲೀಸ್ ಮಾಡೋಣ. The criminal petition is allowed. The order dated 8/6/2024 is quashed. The application filed by the petitioner under section 311 is allowed. The petitioner shall further cross-examine the witness, i.e. PW1, tomorrow, on the next date of listing, that is -nale date ಹಾಕ್ಬಿಡಿ 4/9. So it's 4/9. The further cross-examination shall conclude on the said date itself. Is an operative portion upload ಮಾಡಿಸ್ತೇನೆ on the said date itself.
Suppose that let us be heard because ನಮಗೆ judgment.
No, ಅದನ್ನ
Suppose that-
so further the concerned court shall regulate its procedure in accordance with law after the further cross-examination of the petitioner getting over tomorrow.
Please, ma'am.